My lord, item one. Yes. Small affidavit additional affidavit, file was there. Yes.
Then mention me on it.
Division bench.
Mention before division bench or single bench?
Civil. Single bench.
Single bench. Single bench. We are sitting in division. Don't make any mention now. Yes.
Lordship. Review petition before your lordship. In an ex parte proceeding, lordship, this petition was also dismissed. Let us come to the facts first. Gradually, we will come to the law.
What is the ground of review?
Let
us see the order first.
Yes. Case 98. 98. Annexure 4. Case 98. Annexure 4.
Read. Para 6 onwards. Para 6, 7, 8. At
Yes,
page
yes.
1012, 103.
Yes. Okay. After hearing the submissions made by the learned counsels for both sides, we have perused the original case record FT2 43/03. From the record, it reveals that on receipt of the notice, the petitioner Fosity appeared before the learned member, Foreigner Tribunal to Mangalore, and prayed time to file written statement, and the documents which was allowed, and the next date was accordingly fixed on 2/8/2006, 2/8/2006 also. On 2/8/2006 also, the tribunal allowed further time to file written statement and documents fixing 28/8/2006 for filing the document, etc. Further, it reveals that on 28/8/2006, the petitioner remained absent without steps, and hence on 25/9/2006, the case was fixed for ex parte hearing. On 25/9/2006 also, the petitioner remained absent, and the next date was fixed on 20/10/2006 for passing necessary order, and on the subsequent dates also, the opposite party, the petitioner remained absent without steps, and finally the ex parte opinion order was passed by the learned member for Tribunal number 2 Mangalore. On 2/6/2007, thus, from the record, it reveals that the several chances were given to the present petitioner, and more than 1 year was granted, but he failed to appear before the learned member for Tribunal number 2 Mangalore, and hence the finding no other alternative, the ex parte order opinion was passed by the learned member for Tribunal Mangalore, declaring the present petitioner as a foreigner. The record further reveals that on 9/11/2016, after more than 10 years, one petition was filed before the learned member Foreigner Tribunal to Mangalore, praying to send the record before the learned member Foreigner Tribunal Udalguri, as the record was sent to Udalguri on the point of territorial jurisdiction. The said petition it is mentioned that a review petition was preferred for review of the order dated 2/6/2007, and accordingly the petition was filed on 9/11/2016. Thus, from the entire record, it reveals that the petitioner was very much aware about the proceeding, and he also appeared before the learned member for a tribunal to Mahaldu after receipt of the notice and prayed time for filing his written statement and documents. On the next date also, the petitioner prayed for filing written statement and documents, which was accordingly allowed by the tribunal. But thereafter, he remained absent without steps, and the learned member foreigner tribunal to Mahaldu had to fix the matter for ex parte hearing. There may be some reason for which the petitioner had to leave for his native village at Bihar, but it was well within his knowledge about the pendency of the proceeding before the learned member foreigner tribunal to Mahaldu. But in spite of having the knowledge about the case, he was negligent and never made any attempt to appear before the learned member foreigner to tribunal to Mahaldu, though he was given several chances for production of the documents as well as the written statement. And after long 10 years, he filed a petition before the learned member foreigner tribunal Mahaldu to file a review petition for reviewing the order dated 2/6/2007. Thereafter, the petitioner approached this court after 11 years with the present petition for setting aside and quashing the ex parte order opinion passed by the learned member for the tribunal to Mahaldu. So, considering the entire facts and circumstances of this case and the negligent conduct of the petitioner proceeding, we are of the opinion that the learned member foreigner tribunal to Mahaldu had rightly quashed the impugn opinion order and arrived at a correct decision holding the petitioner to be a foreigner. Accordingly, we find that there is no perversity in the impugn order opinion dated 2/6/2007 passed by the learned member foreigner tribunal to Mahaldu in application number 43/06. Therefore, the present petition, the petition being devoid of merit, stands dismissed. Lordship, discovery of new and vital documents and whatever documents were submitted before the Honorable Division Bench were not taken into consideration. That I will gradually come into. Kindly come to case 4 of my petition, facts part. Then I will come to the,
Why should you consider your? You approach the division bench earlier against the order of the ex parte order of the tribunal,
Lordship.
only for the exercise of the power under such order. We did
Lordship.
not find any such irregularity in the order passed by the learned tribunal. What is the ground of review? What is the ground of review now?
Lordship, kindly come to case
Cannot-
83.
After cake and eat it too.
Lordship,
You have taken 10 years,
Lordship,
right?
that
And then you approach the court again.
the
There has to be a genuine ground for it.
yes, Lordship.
That you have appeared before the tribunal. Time.
Lordship,
It's
that's
not that whenever you will feel like you will appear before the tribunal or before the court. And whenever you feel like you will not appear, then one fine morning you will feel that no, I should go. Or I should appear, then you will appear. Is that the law laid down by the?
Lordship, Lordship, I will go to the law. I have
Tell us,
numbers of yes.
as party according to the wish of the petitioner, it will happen.
No,
Is it possible?
not possible. He is a rustic villager.
That is a
Lordship,
simple, law is equal for all, whether rustic or in the rich. We're not.
father, grandfather,
That
grandmother,
is an issue
everybody,
that you should have raised before the tribunal, not before this court.
because tribunal expertise that I did not have filed even written
That is
statement.
your fault.
That's why
Question of continue, that is the reason, tell us, what is the illegality in the order of the tribunal when the division bench considered the matter? The division
Lordship,
bench looked at the records.
kindly come to
We are here only to exercise.
Yes,
the
yes,
power
yes.
under certiorari and nothing else.
review jurisdiction, plenary jurisdiction.
Show us the illegality in the order, that's all.
Lordship, kindly come to
Show us the illegality in the order. And not beyond that. So it's like-
kindly for a time, kindly come to page number 19. Yes. Roman 2, ground. For that, the learned court took serious objections to the failure of the petitioner to file a written statement, and the documents, despite his petitions, were allowed granting adjournment on several occasions, and thereafter the petitioner remained absent without steps for which the case was decided against the petitioner ex parte. Thus, the Honorable High Court assumed that those
What
several
do you want to
chances,
say from this particular paragraph? What do you want to state?
the petitioner being a
What do
village.
you want to state? Tell us on law, nothing else.
Yes, I'll show a
Whether these
decision also.
statements will not come now, that should have raised before the tribunal, which you have missed.
Then kindly come to page 22, ground number 3. That the Honorable High Court, along with the writ petition, the petitioner submitted as many as 13 documents, A to M, annexure, including vital citizenship documents of his father and grandfather, the land document of 3
Now,
1959.
kindly show us any judgment of this honorable High Court or of the honorable apex court that the court, while exercising the jurisdiction under statutory, has the right to look after such documents and to consider personal order when the matter relates to an order passed by the constitutional authority. Show us any such judgment. We consider now. But it has to be in exercise of the power statutory, not in a writ application.
Kindly come to page 150, annexure 23. I have annexed 3 judgments.
Will not consider.
Yes. Annexure 23, page 150, Doctor.
150.
150. 150, Doctor. Yes. Constitution of India. Doctor. This is Paritos Das versus Union of India. Recent judgment, Doctor. Review, Article 286, grounds. Discovery of new and important matter of or evidence, documents, land revenue receipt to show. Problem is, the petitioner before your lordship, they originated from the state of Bihar. In 1970, his father came here. His father is a voter here. His brother is a voter here. His wife is also a voter here. Only that 10 years he went to Bihar, he remained there. Revenue. এখানে দেখুন, এখানে দিয়ে দিবেন। I am submitting this. So, journals for this review petition. Ah, hay আছে তো, তো এইভাবে তো ভালো লাগছে, ভালো লাগছে। Copy to the.
When did you first appear before the tribunal?
Last in 2006.
Give us the date. Yes, when did you first appear?
Order reflect pilot 2/8/2006,
No,
but
no,
it should have been a date prior. Exact date.
give us the date. Where is the copy of the notice? You did not annex in your petition release. You might have it.
Copy of the notice might be with him, but it was not annexed earlier. But my lord, another judgment is at page 145.
We are not on that. You can show 100,000 judgment that there has to be a reason. The judgment that you have shown before us. Come to page 152. Read para 14.
Yes, in the original records, it is seen that the verification officer's report, it has been mentioned that the father of the petitioner is registered as an electoral and his name appears in the voter list of 83 Duraburi 1970 LSC part number 2 at serial number 640 in the state of Assam. Though it appears from the inquiry report that initially there was a remark that no document was furnished, the said remark was crossed out, which means that the petitioner might have been able to produce some documents to show that he is an Indian.
Then,
So my case is, Lordship,
hold on. Don't jump. Don't jump. Have you annexed the opinion of the tribunal?
tribunal's order,
Yes.
tribunal's order, Lordship. Yes,
Which page?
that is at page 82. The lecture day.
You have just read para 14 of that judgment on the basis of which the coordinate bench considered for review. Now, you read page number 83.
Page 83.
Yes.
According to LVO, he made the verification report as per direction of ER Mohaldu and filled up annexure A, B, as per version of OP. During the verification of OP, he could not produce any other document. It is his admit card of Seva. That is, we have also annexed in support of his date of birth. He could not fill up the column in annexure A and B as OP could not foreigner any other document for this. I have gone through the above or find that OP has duly acknowledged notice of this tribunal, but no document is produced to prove himself as an Indian national. The LVO is responsible for, he made the inquiry on duty as responsible government officer. His report in annexure A and B before the tribunal cannot be discredited. Further, the argument of learned AGP Moholdoi has reasonable ground to believe that OP is a foreigner for which he could not produce any document in support of his nationality. Considering above, I have declared officially Mahesh Kumar Jha is foreigner and disposed of the case accordingly. My lord,
That is the difference. In that particular judgment which you have cited, the coordinate bench found that in the verification report, the voter list was annexed or placed where the name of the father of that prosody appeared. But in your case, when the verification was made, there was nothing before the verification officer. And you failed to place any document except your admit card,
lordship,
right? At least you would have a voter list.
lordship,
There
I
was
was
nothing
not the
before the
voter.
before the verification officer.
My father's voter list here
That
in
we are not
Assam.
going to hear now. The ground for review in that particular case, that the verification officer, while submitting the report, have clearly stated about that proceeding. That it was a voter list of the father of this proceeding. But in your case, nothing was there excepting your admit card. Law is well stated that long stay in India will not make you a citizen of India.
Lordship,
So us, that is the reason we are asking you to consider the review. You have to place certain material. Where do
his father,
you are
Your
not going to hire his father, his grandfather, because you have not filed any written statement before the tribunal, in spite of taking time. Why should we hear in a such a
lordship,
Please tell us
The-
the
these-
reason. Please tell us
documents-
that is the reason, please show us anything material from the inquiry report or anything that you have placed before the tribunal to find out that the order of the tribunal was bad in law. You have to exercise review, not seeing the, or considering the case of the proceeding or seeing your face, but on the basis of certain legal issues, right?
lordship,
This is not a market. To
exactly,
consider your, this is not a panchayat. You have to place the relevant provisions of law,
exactly,
Source.
lordship.
Mr. Islam. So
I,
or you leave it. Show us any material to consider. That we have said, para 14 of the judgment you have placed is very clear. that certain material was there for the lordship to consider the case. Where is the oath?
but being a
If you
village
have, tell us. Don't make
rustic,
any submission further. If you have some materials, tell us, or otherwise you leave. That's all.
that the documents annexed
We are
before
not going to
the,
hear, because those documents were not before the tribunal. Don't bring those documents before this court. We are here to only to see what is the lacuna in the judgment of the tribunal. That's all. Nothing else. And we are bound by the law laid down by the Honorable Apex Court.
lordship,
And we cannot go beyond that, even if you make any other submission, Mr. Counsel. Tell us, that you bypass the order of the judgment of the Apex Court and you should go and consider your case.
lordship,
Tell us any such judgment of the Apex Court will consider.
lordship, I have,
Where is the judgment of the Apex Court? Tell us,
yes, lordship.
which page?
First judgment,
That is
2004,
relating- That is not in exercise of the power of the certiorari. Green view is a different matter altogether. It is a T state matter. I appeared in that case, I know very well.
then the third judgment, lordship, 1993 supply court, as Nagaraj and others of the state of Karnataka. Here, lordship, kindly come to page 35. Page 35, paragraph 18, lordship. Justice is a virtue which transcends all barriers. Neither the rules of procedure nor technicalities of law can stand in its way. The order of the court should not be prejudicial to anyone. Rules of stare decisis is adhered to for consistency, but it is not not as inflexible in administrative law as in public law. Even the law bends before justice. Entire concept of writ jurisdiction exercised by the higher courts is founded on equity and fairness.
What is the background of the case? Nyas Nagaraj. Was
Uh,
the matter relating to the foreigners tribunal?
It was
Or
not
the matter
a,
relating to the certiorari?
it was
There was a scheme in the state
certiorari
of
against some writ petition.
There was a scheme in the state of Karnataka for employment of unemployment persons, right?
Lordship.
There the case of the petitioner was not considered. That's how the Yasnagar case is their background. How it relates to your case here?
Only for
See,
the,
don't bring one particular sentence to another judgment of the apex court. That will not help you. That is not the background of the case. We are asking you, show us any such judgment in exercise of the power of the certiorari. The honorable apex court has considered such review, not in any other reams.
even in Sarvananda Sonwal too, Lordship. Kindly come to page 71,
70.
one of my compilation.
Yes.
Sarvananda Sonwal two.
Sarvananda Sonwal to us for what purpose? What
Yes.
happened, Sarvananda Sonwal two? What is the background of the case?
For
what?
establishing foreigners tribunal.
For what? There was a direction by the honorable apex court,
Yes.
Sarvananda Sonwal one, it was not complied with.
Comply.
When there was a matter of place before the apex court, hurriedly they have placed another notification. That was challenged. How it
Lordship.
relates to your case?
But procedural parts, Lordship.
We are asking you, show us anything on the while in exercise of the power of certiorari. The review has to be considered in these grounds. Show us such material will consider your case. Straight away tell us if you have any such judgment. While
Problem is,
exercising the power of certiorari, the review is to be considered in these manners. Tell us, we will consider now.
even in Muslim models case, Lordship.
Why Muslim
Procedural,
model? What is the background?
procedural safeguards, Lordship.
This is a question of procedural safeguard. It is not a fact that you have not been, you are not entitled for that. But when you have missed the bus,
Lordship, I am admitting 100 times.
then that is the.
I am a
reason I'm asking
rustic
you.
villager. I do
Where
do
is
not
the
know the
power of-
procedure of,
Where is the power of this court while exercising this certiorari? To set aside the order of the tribunal and grant you time.
then one judgment, Lordship. My Lord Justice, that is, I have annexed in my review petition, annexure 21, page 139.
Yes.
Page 144, para 11 and 12 is irrelevant, Lordship.
Read para two,
My Lord,
read para two, page number one.
para 2. The appellant writ petitioner case is that he is an Indian citizen and permanent resident of Taglabadi, Bara, Post Office Pohumora, PS Barpeta in the district of Barpeta, Assam. The Azara police in connection with the Azara PS case number made a reference to the illegal migrant determination tribunal in short IMDT, as it was then, by registering a case being case number 518/05, alleging that the petitioner, being a Bangladeshi national, entered into Assam after 25/3/1971 and illegally resided in Assam without due permission from the government of India. This said reference was converted into a proceeding under the Foreigner Act, and accordingly application number 443/07 was registered. The Foreigner Tribunal, Kamrup, Guwahati issued notice to the petitioner, and accordingly he appeared and submitted some documents in support of his claim regarding Indian citizenship. However, subsequently the petitioner failed to appear before the tribunal and substantiate his claim by adducing any evidence. Accordingly, the learned member of the Foreigner Tribunal, by impugn order dated so expertly disposed of the case, declaring the petitioner as foreigner, observing that he entered into Assam after 25/3/1971.
Read para three.
According to the petitioner, after receipt of notice from the Foreigner Tribunal, Kamrup M, he submitted necessary documents in support of his claim regarding citizenship. with the office clerk of the tribunal.
Yes, please.
Yes. With the office of the clerk of the tribunal, who assured him that those documents being genuine would be placed with the case record and that the proceeding would be closed very soon. Just like my case, Lordship, I
Proceed. Very clear.
therefore, as pleaded by the petitioner, he being a poor, illiterate and ignorant person, under bona fide belief that his documents would be accepted in his favor, did not appear before the tribunal. But the tribunal decided the case ex parte without taking into account the said documents placed before it. He has also pleaded that his non-appearance was due to his ignorance and lack of knowledge and information about the legal proceedings. He further stated that he had no knowledge or information about the order passed in the said reference and that he came to know about the said ex parte order only after receipt of the notice sent by ERO of 43 Kolkata LSC. According to the petitioner, he submitted total list of 1997 and 1993 and NRC certificates from the Gampura and the Panchayat Secretary in support of his claim of citizenship. But due to his ignorance, he failed to prove the said documents, for which the learned member foreigner tribunal decided the case against him.
Your case is similar. Like this. Don't jump, that is the reason we are asking you, whether you
Not-
similar. So when it is not similar, don't click.
Not exactly, but it has a similarity that
When the case is not similar, don't place it. Here is the proceeding who submitted certain documents before the tribunal. But he did not prove it. But in your case, you took time and did not submit anything in spite of renting 1 year. That's the
I-
difference. Now, show us any other material to consider it. See, this is not a market that when you feel like
No,
after
no.
a year you come, when you feel like after 10 years you'll file a writ petition.
I was
You
not
stay
here.
Bihar. You wanted to Bihar, you stay at Bihar. That's all.
That even
When that is the reason we're asking you, whenever you'll feel like you'll come back and then you'll file a petition and court should consider it. Is that the law? It's settled by the apex court.
but his father
Mr. Islam, kindly tell us.
even regarding that specified territory. Lordship,
We are not on that much. If you have any material, tell us. Up to you.
notice and other parts I will satisfy. Let it
But
attend.
not notice satisfy is not the issue. Where is the illegality in the order of the tribunal? You have seen the difference between the other cases and your case. On that basis, tell us.
That read court has plenary jurisdiction.
Not
Lordship.
in search right, not in search.
So difficulty is the
That is the difference. See, reads are various types, right? Reach of habeas corpus is there, reach of mandamus is there, reach of poor and is there. That is something different in each read.
I am a Moithali Brahmin, Lordship. Lordship,
You have a
Due to my-
license of motorcycle, you have a, you can write in English. Don't tell me. Don't tell me
So-
those things before the court.
I am a genuine
You are a-
Indian citizen, Lordship.
You are a genuine citizen, no doubt, but you have to prove that. You have failed to prove that. You miss the bus.
Lordship,
You want to go by 5 o'clock bus or 5 o'clock Rajdhani Express. You miss it. You have to go by the night train or night super. Can't tell you. And the foreigners law is something different.
okay.
It's not where the burden is on the proceeding.
That
And then, see, 1 year you have not filed any return statement or everything. We have
That-
the court after 10 years. You left this place because why you have left this place? You have property, you have everything, you have left for Bihar or what? Knowing fully well
For some
that
business,
year-
I,
Now you
I,
can say after 10 years or 15 years, you can come back, say that then you have left for some other place.
Lordship,
Help you. That is the reason you are asking you.
I have opened it.
So, Mr. Islam, or if you want to read
So-
some more judgments, you read. Mr. Pai, I am giving the judgment of the apex court, Justice Paliwala judge. Let him read what is exactly. See, that is a wonderful case where there was no reason for the apex court to say so much about the law of certiorari. There is no reason. But there was a small loophole in that particular case. That is why the Honorable Apex Court, in that judgment, from paragraph 50 till its end, have written about the law of certiorari. To make it clear, everything, where is the power of the High Court in exercising deed of certiorari under Article 226. Relation has to be given by the Apex Court to all the High Court. Read that judgment, Honorable Justice Pariyo. Then you will realize the court found that while exercising the power of writ of certiorari, to what extent they have moved, where there was no such power. No, you cannot go beyond the law laid down by the Apex. Read it. And if you want to make a submission after reading judgment, come back. Up to you,
All right. Give me some time.
Mr.
I will set it
Fine,
up.
give him the judgment.
Yes.
And make him submission after that. When?
But,
In fact, my lord,
Yes, when?
in the month of May, Lordship. May 22 or 20.
After taking the prayer of the council for the petition, they the matter of we make next regular reporting. When
Meet with Lordship, I am praying for listing of a regular bail application from day after tomorrow. Obliging. Okay. Obliging. Similar to your Lordship.
When did you file, anyway?
11th, your Lordship.
You had a filing number, so.
Yes, it's registered.
May I praise the Lordship? Lordship, item 43, CD not received, Lordship. Next week, any date, Lordship?
Abhayapuri Malat,
From which police station?
Abhayapuri Malat.
Are you any injury? Sir, give us a date.
No,
No, no, no, Lordship.
First of May month.
Lordship, next week,
Okay, first May.
Lordship, another prayer, Lordship, item 6, Lordship. Taken up any other day, Lordship, today for some personal difficulty. Next week, Lordship,
After you wait,
Lordship. Oblige.
May I please, your lordship, I beg to mention item number 18, lordship. Lordship, need to file an additional affidavit, lordship, so that's why I need some time, lordship.
tell us when to be listed.
Sorry, lordship,
Tell us when to be listed.
lordship,
You give us the date.
2 weeks.
Give us a date. It's there before you.
Lordship, 1st or 2nd of May, lordship.
Give us a date. Date, CAT.
2nd May, lordship.
Library Council to the petition. 18, no? Based on.
18.
Here,
Table, sir. Item 10, motion.
item A,
10,
10.
yes, ma'am.
Yes, what's your prayer?
Maybe pass over, ma'am.
Please.
List after we.
Please, your lordship. So regarding item number 31, perhaps this area is not available.
Which police station?
Mukalma police station.
Yes, well, 3D not taken.
This is for the first time, Mr. Not, or it is,
It's the second time, my lord.
this Mukalmua, what is happening with Mukalmua?
Signal, my lord, but on 27/3,
Give us a date,
second, my lord.
It's an interim order, my lord.
31.
31, my lord. There's an interim order. 30.
Second of May, my lord.
Okay.
Interim to be extended, my lord. But there's another prayer, my lord, for listing of an IA for correction of an order. Order was passed by Honorable Mr. Justice M.K. Kulika. Today he is not sitting. Tomorrow, my lord, subject to his availability, my lord. Because bail was granted before vacation, my lord, but there was a error in mentioning the jurisdictional court, my lord. So I could not submit bail bond.
24th.
Deeply, Lord.
May it please your lordship, I beg to mention item number 41, lordship. The city not received mail.
From which police station?
Moribari, lordship, Morigaon.
41 subsequent city.
Excuse me.
City received.
Any other date, lordship?
Or any interim
No entry.
next week.
Next week.
Till
Obligement,
city will be received.
obligement.
May it please your lordship. I beg to mention item number 12, your lordship. Can be up to some other day, your lordship.
After you correct it.
Can be in the month of June, your lordship.
Okay.
Interim to continue, Lord.
There is an interim.
Yes, your lordship. Staying the PRC case number 2219 of your lordship.
On which date?
On your lordship, 12/2, your lordship.
This year?
Yes,
Last
your
year?
lordship. 12/2/2025, your lordship.
Okay, on 28. 28.
May it please your lordship. Lordship, with regard to item 20, I have filed an additional affidavit on 10/11, 10/4, my lord. It may not be on record, so if not, I may be allowed to.
You want to bring it today or some other?
Today.
May it please your lordship, with the consent of the other side, my lord, I beg to mention item number 13, my lord. Can it pass off for a day, my lord?
Have you informed?
Yes, I've informed, my lord.
After a week on a date to be fixed.
Deeply obliged, my lord.
May it please your lordship. I beg to mention item number 25, lordship. As per my instruction of my client, lordship, I may be allowed to withdraw this bill application, lordship. Item number 25, lordship.
From which police station?
Gitanagar police station, lordship.
But Mr. Peter Kuya council appearing for the. And Mr. For hospital and education. Right. An instruction on the petition. Mr. Tapuriel and council. Not pressing this bill. Council.
Must oblige lordship.
Your lordship,
Yes,
your lordship, I apologize, your lordship, as regard item number 12. It was fixed on 28/4. Can it be in the month of June, your lordship?
no, there is interim in court.
Yes.
Cannot be.
Yes, Lord.
Oblige your lordship.
May I please, your lordship? Lordship, I beg to mention item number 32. Lordship, in this matter, 30 was filed. 30
Has it already filed?
already filed.
We have the number,
My lord.
No, lordship, thank you to inform.
CS number you have?
92/25 dated 28/2/25.
So we are on interim, lordship.
28 February, 28 February 24.
What's your good name?
BP Sharma.
Sir, I made. That was for the pitch. Plan of also. Petition number 95. File the application of particular. I ordered the 22/01/2025. And it- and then I- So, the product is- Which is the info. During the deliberation of the matter, Mr. Products of addition for. That will complete the speak. Come to that circle. Include property inspection. On 28/02/2025, I started my. Next. Review paper. The petitioner is not directed to appeal. Before the appropriate court. For the regular bail. And say to that. On or before. 9th of May. No further.
Repayments. Item number 30, up to date CD has to be, confirmed, but they have not taken back the CD due to some election related purpose,
30.
30, once, that, these are petition,
Give us a date.
interim, is an interim, 7th of May,
For up to date case diary.
Amal-
7 is the Panchayat election. Why you are-
yes. After that,
Okay. You have it sometimes around 15th of May. 30, right?
Item 30.
15th. May. Alright. You are an interim. Yes, ma'am.
Ma'am, please, your lordship, this is for listing of the criminal petition, your lordship. Kindly matter may be fixed on 7th of May.
When did you
For
file?
admission.
When did you file?
Uh,
Do you have the filing number? or you have the-
17/9/24.
You have filed. You will have the number.
What's filing number? Yes, lordship,
You are praying for listing it on 7th of May.
7th of May, yes,
Not
lord.
now. You make
For
your-
admission.
You make your prayer on 2nd of May or 5th of May. Too early for fixing any such case on 7th.
Oh, bless you, lordship.
May I please, your lordship, the item number 16, 44 lordship. Or adjourned today.
You have the case diary.
44.
On Monday, lordship.
Medical.
So it is available,
Friday. Friday.
not Friday. What is, no difference. Today or Friday,
Monday lordship.
then there will be different. Not on Friday, Monday,
Monday.
Monday prayer.
May please the Lordship.
Yes,
Lordship, I seek your permission to go to the trial court records of item number 29, my lord. DPO, let me.
May I please, Lordship? I mentioned this item yesterday also, Lordship, for unlisting hearing, Lordship, anticipated bail. This, as per the allegation, Lordship, the plea of for adjournment, my lord, in item number 9, my lord. The first week of May, my lord.
The second is submit. Second. Fifth of May.
Obligement.
May I please your lordship? This is a bail application under section 483 of the NSS in connection to North Guwahati Police case.
10 copy has already been called for, Lordship. It should be listed for hearing, Lordship. And the records are not received.
Where is the office code dated 11/04/2025? Just a reminder. Do you have the case number before the learned special judge, session judge, Kamru coming down?
Yes, your lordship. NDPS 03/2024, your lordship. Pending before the Honorable District and Session Judge, Kamrup Rural.
For the legible second copy of the records of NDPS case number 03/2024. Rising out of what NDPS case number 211. 2024. Corresponding to your number 117. What is the case number 2023? It was called for. I ordered it to one to the food. Placed on 6th of May.
Much obliged, your lordship.
Yes, it was.
My lord, I'm seeking bail on arrest procedure draft now. Page 34, 35, and 36.
Legible scan copy of the records of special NDPS case number 44 of the 2024. Adding out of settlements, police station case number 226 of the 2024. Correct. From the court of Lanet, special judge, NDPS competition judge. Sri Bhumi. Karimban. As on 25/04/2025. placed on 8th of May. Registered official.
I think this matter may be referred to appropriate bench as the co-accused have been granted bail, my lord. The coordinate bail.
You have a copy of.
Yes, ma'am, I have discussed this.
Mr. H.R. Chaudhary, counsel assuring to this petition. I think that. Before accused. In the special NDPS case number 17 of 2025 arising out of Karimganj PS case number 17 namely Khasrul Islam. Has already been granted bail by a court in advance of transport. By order dated 11/05/2025 in B.A. 1142/2025. And as such, great for listing of this matter before they have written.
Obliged.
Ready, but. Khasrul Islam and Badur Rahman.
Obliged.
It's the appropriate time.
My lord, scan copy. My only prayer at this stage is can these two matters be fixed on 2nd of this month, my lord.
See, let us see, it has to come from which place?
My lord, Handy College, this Kamrup.
Letter has to come from Hindi College.
Handy means, I mean, this Kamrup, that metro near that Handy
In
College.
Hindi College.
No. 25 years back, 25 years back. Just across the street.
It's actually- Nice.
That's the landmark, my lord.
All for the records of NDPS case number 129 of the eligible stand for. And then 25 people. And for 22 NCP crime number 7. From the Court of London, special judge NDPS come additional such and number to count of matter. Okay, so this will form and list on.
2nd of one, lord. She has also agreed to that, my lord. I requested her.
If the court can send it, no problem.
My lord, on 2nd, I'll take
Make
it.
it on 6th, that is better for you. That Tuesday, it can be hard.
My lord,
6th of May. 6th of. What is the registered official?
next item, same, say, accept the case number. And additional session judge 2 and case number is different. Rest all same.
Case number 12202. Corresponding to NCP crime number 35. Put it simple. Huh? Same date, same.
Additional session judge 2.
I have left.
So this criminal petition has been filed seeking Jimma of the case seized by the police. Also, you filed the FIR at page 20. The case is registered under section 13 and 14 of the Assam Games and Betting Act.
Mr. Sharma,
Lordship.
just, the case is pending at what stage?
The investigation stage, 12 months have been passed, but charge sheet has not been
In
filed.
the, report from the IO, that's what.
Lordship.
It relates to the of the article. Seized in. Municipal police station Case number 122/2024. Right. MR number 131/2024. 10205/2024. I cash amount of rupees 62,82,890. And what mobile phone?
iPhone 13.
iPhone
13.
and phone. Mobile phone. iPhone 13.
13.
Super. List on 7th of May. And I'm doing the investigating officer. Of the Insuria PS case number 1. Case report.
Apply.
Yes, ma'am.
Yes, great to the Lordship. Lordship, before submission, I have a small pair, Lordship. Lordship, in paragraph number 8, we have a typographical mistake. We have wrongly typed the case number and the code number, Lordship. Will you kindly allow to correct the paragraph, Lordship?
Page number 8.
Page number 8, Lordship. And paragraph 5.5.
What? Chart sheet number.
No, Lordship.
We go to council appellant for the petition. From that. Round number.
Down number 5, Lordship.
The important typographical error. And check page for correction. Typographical error relating to this company. It is also directed that a petition is council correct. Replacement but when do you want?
Lordship.
After tomorrow or next week?
Lordship, next week.
Next on. 28.
Oblige, Lordship.
Make it on 29. 29. Yes. Yes, Mr. Fukan.
Lordship, we are also, there is a reasonable apprehension, Lordship.
Paragraph 3, left.
Hmm?
Paragraph number 3.
Get the information.
Lordship.
When?
Next week, Monday, look. Or Friday.
List on 29. And I'm going to Chapi Sharma added the any case of in the history. Police case. Against the petition, we perform good time. Under the case.
Obliged.
May be lost.
My lord, in this case, my lord, the vehicle of the petitioner, my lord, commercial vehicle, my, that was seized, my lord, on 31/2024, lordship. For more than 1 year, lordship, the vehicle is under custody of the police, lordship, in the, under open sky, lordship. The custody was allowed, lordship, but the bank guarantee was given, lordship. That is why I could not take the, my lord, vehicle under Zimma, lordship. This is, my lord,
Definitely, you are required to produce the vehicle during the time of the trial.
my lord, I am unable to, my lord, my lord,
What is the price of the vehicle?
price, my lord, this is the second-hand vehicle, my lord, my lord. Price is not written in the, my lord,
Trial court has looked into it.
not calculated losses. Without calculation, my lord, this is the, my lord. On the other hand, my lord, my lord, similar, my lord, in the similar case, this honorable court, my lord, granted, my lord, personal bond, my lord.
For a vehicle, it is difficult.
My lord, kindly see that order, lordship, similar order, kindly
You
address
indicate the vehicle, it will not be able to produce during the, and the charges will not be proved because of the absence of the vehicle.
Now,
Sir Sharma,
lordship,
there's a judgment of the apex court that the it will be videographed and all,
yes,
right?
yes.
So whether the vehicle will require, only the IO can say at which stage. What is the state of the proceeding?
My lord, now, as far so far information is concerned, charge sheeted, the case is charge sheeted lawsuit. My lord, my lord, in the, there is a, interpretation of section.
Whether charge sheet has been filed or not.
My lord, today I talked to it, my lord, but, the copy was, my lord, was not, my lord,
Let us know the stage of the proceeding. That was the time when the, after that, during the investigation, you sought for Jimma, right?
yes, lord.
Now after that. What was the try to put the court again?
Now, my lord, my lord, after charge sheet, my lord, as per the, order passed by this honorable court lordship, after charge sheet can, the vehicle cannot be, my lord, taken under, my lord, custody, insisting, my lord, bank guarantee lordship. The section 11 of the, my lord, Cattle Preservation Act, my lord, has been interpreted by this honorable court lordship. This is also reported order judgment lordship.
Get the information when the search sheet was filed, what is the number?
My lord, number is not given, my lord. I have instructed, my lord, tomorrow, today, it's a, my lord, I got information the charge sheet is submitted, lordship. I could not issue, my lord, learned friend can, my lord, obtain.
Get it from your client.
My lord, this is a, my lord, the government can, my lord, learned PP can take instruction whether charge sheet is submitted or not, lordship.
The issue, the order dated 3/1/25, lordship, at page 17. It is specific, lordship, that the vehicle may not be required, lordship, but only the issue is, lordship, regarding the bank guarantee.
Yes, lordship.
So, lordship,
The bank guarantee is given only when the, because if the vehicle cannot be produced. during the
Yes,
trial.
yes.
That's the reason.
yes.
Any other, my lord, assurance may be, surety can be, my lord, directed to be taken, my lord, the, I have landed property lordship. Bank guarantee, my lord, it is very difficult lordship for the, this, my lord, type of person, because, my lord, available money is required to be, my fund is required to be available in the, my lord.
Estimated any amount.
Account.
Clearly mentioned, I don't think so, they have to be interpreted. Subject to furnishing of bank guarantee equivalent to the market value of the vehicle.
It is
This
not
discretion
determined.
of the court, that's all.
There is nothing wrong.
There is nothing, there is no illegality in this.
It is not calculated lordship.
Equivalent
Who
to the
will
market.
assess? Court will able to assess.
Now, what will be the market value lordship? Oh,
Definitely, who will able to assess?
this is not, my lord, brand new vehicle lordship.
Who, the court can assess? Just tell us.
Now, kindly see this order lordship. The order. It is submit for you, huh? This is reported lordship, this is reported the Supreme today lordship. It is specifically stated, my lord, that the section 11 of the, my lord, Cattle Trespass Act is, my lord, up to the, my lord, seizure, my lord, and reporting to the magistrate lordship. Then, my lord, the honorable Supreme Court judgment, my lord, this, my lord, Ambala Desai, my lord, Sondor by Ambala Desai, that should be followed,
So
lordship.
it didn't tell us. Every case, Archit was already filed. Right?
My lord, then it might be fixed, my lord, another day, lordship, I'll try to produce, lordship, the copy of the charge sheet, lordship.
Mr. Sharma,
Lordship.
can you get it?
Lordship.
Whether any charge sheet has been filed, it's so. Note from Bachalam to. Day after tomorrow. Next week. Nothing. Mr. P. Sharma. It's over. The price is changing. In Bachalam. Police station case number 55 of 2024. I need to. Source number. Along with it. Requested.
All right, lord.
No representation on this. Five council. What's your good name?
Yeah, my son.
Or- List of pretty weak.
May present lordship, the Zimma for track lordship, commercial lordship. The seized on the 23rd December 2024 lordship.
Mr. Sharma, you
The
have the-
basis of the five.
We have received the communication, AYO could not send the CD, lordship, along with the report. A date may be fixed, lordship, on the next day, I will.
We don't need the CD, only the report is.
Yes, sir, only that report, lordship. He was busy in law and orders.
The earlier occasion, the same prayer lordship, the.
Make it.
This is the, the fourth master here, the master.
Okay.
The master. As well as right. The Bogisto PS lordship. The commercial vehicle lordship.
By order dated 19/02/2025. Report, call for the report. From the concerned investigating officer. Of Worcester Police Station case number 920/2024. As to whether. The. Zimma. What vehicle,
The track lordship.
what truck?
The lordship
Truck, Indian
space
truck.
21 lordship. The registration certificate.
The Zimma of Tata truck. Bearing registration number
AS01 FC
AS 03X01 FC.
89994.
Seized on. When it was seized,
The lordship the says on the 23rd December 2020.
it was on 25th April 2024. Next week, so it's supposed to be this. In spite of renting time on 11/03/2024, 18/03/20, sorry, 11/03/2025, 18/03/2025, 04/04/2025. The concerned investigating officer of safe affairs case failed to submit the report. Even today, such report, because sought for the report on 19/2025 has not been placed. Mr. Sharma, narrated the of yes, great spot. On the plane. Placed on
Mandela.
13th May.
The short date may given lot. Bosishto Piaslo.
The concerned investigating officer of the PS personal pertaining to people. Failure on the part of the concerned investigating officer to submit the relevant report that was sought for by order of the 1925. I say it here, he shall have to partially be provided. He shall have to partially be present to the report and indicate.
Lordship short date may given lordship. Already 4 months gone lordship.
Lordship, a copy of the order. Copy of this order.
May please your worship. Actually, in this case, you filed an additional affidavit yesterday. Perhaps it has not come on record, my lord. And let it come on record, my lord. Fix it next week, my lord.
Mr. S. Nawaz, counsel appearing in the petition as meditation like the 5 yesterday. Indiscriminate conviction. How? How the son placed on 30.
My lord, kindly fix it in the second week of May, my lord. 5th, my lord, if possible.
Based on 6th of May. We have the consultation. According. The digital incorporate.
I'm deeply obliged, my lord.
Can the evidence of the victim has not been received. Office note 11/4/24.
There is no representation on behalf of the petitioner on call. So. Name of two counsel that we reflected in court. Art Mr. P. Sharma, and independent prosecutor. Preparing for the state. Suspended one. And in this unpaid loan and Marcus PD. For the informant responding to. Where is the office note? 11/04/2025. Issue reminder. Today. That's it, not it file.
That's it.
Special Dutch box. Walpara. For the copy of the evidence of the victim girl as well as the informant. Of- with no case. And that was not for. By report by the order. Based on 15th May. This order is not against. Not separated.
Material. Item 15, Lordship, I'm on this one, Mr. P.D. Nair. He is the, to say, water logger, he is not coming, being for this code.
Prepare the council for the. We can get to be.
Obliges.
My please, your lordship. Lordship, in this case, my lord, I have filed an additional affidavit on the ground of notice under section 47. My lord. The ground of arrest has not been furnished.
Where is your additional affidavit?
Additional affidavit, my lord,
When did you file?
I have filed on 10, my lord, 8/4.
During the. Flag.
10/4. my lord.
By filing an additional affidavit. On 10/04/2025. In this bill application. The petition. Raised a new ground. That. While arresting him. On 13/12/2024. Units in Mankacha Police Station case number 219/2024 under section 22 in bracket C. Public 29 of the NDPS Act. Corresponding to GR number 507/2024. The authority concerned did not comply with the provision of section 47 of the 48 of the BNFS. And thereby violated the provision of article 31 and. Constitution. Issue notice. Returnable by.
TD is there, my lord.
they have to file an affidavit.
मतलब 2 days, 130 days.
Mr. Sharma,
Lordship,
file it on or before second.
can, Lordship.
Submitting copy. The state. Respondent shall file an affidavit in the on or before second. Submitting copy of this. That's it. Counting. Placed on 5th of May.
Lordship, I have just been informed that our High Court has received a bomb threat.
Huh?
A bomb threat,
Bomb threat.
yes. Lordship.
ND 24, my lord. Come. Let it blast. Only the police, my lord. Take up. Say, certain things are there.
Look. Yes. Yes. Yes.
Mr. Gogol,
Lordships, a woman came from Bukakhat to Guwahati after being arrested by the police 365 days more. And this honorable court has initiated for the charge sheeted case, Your Lordship. Case one witness has already been examined. My lordship dated on 19/3/2025. Then thereafter, medical report has also been clarified regarding her present status of the health condition. Two data are there, Your Lordship. One is
medical report has been submitted.
yes, it has been reported clinically stable. It has been mentioned. Now her health condition is fluctuated due to the diabetes. Without going to the merit, Your Lordship, I simply because of the length of detention. Your Lordship. This is the first case. Family members are shattered. There's a case.
When you visit the jails, you are also human being. We feel sad when you see the females. See, I have visited almost numbers of jails.
Yes,
not
yes,
say
yes.
almost all. When I went to Karimganj, we found a young girl, Mijo girl.
Yes, Lordship.
That's the corner, the triangle.
Mhm.
coming from Myanmar. And see, neither can speak Hindi nor English
Yes, yes.
because they knows only Mizo. And see, she carried these items and tried to know from her.
Lordship.
And she informed us that she came along with her boyfriend. The boyfriend have asked her to leave. And boyfriend said, "I'll just come for a few minutes." He left. Police took her. Of course,
This is the four persons.
here it is, see, they are in a group.
One has been granted bail, jubilant. And I have annexed the documents regarding her school, his school, admitted in the West Guwahati Jalukbari school. And whole life. Even your
Difficulty is with regard to drugs, it is difficult,
yes, yes, exactly.
not for other. What is the quantity?
It's around 252, 257 your lordship, but in inventory it is in 262 with polythene your lordship. If we deduct, then it will become 220, not in a commercial quantity. Your
It's a
lordship.
heroin.
Heroic. Your lordship. Only point is that your lordship, my point is that your lordship is maybe or may not be your lordship. I leave it to your lordship. But the point is that your lordship,
It's very in custody.
365 days, 5/4 lordship, 2024.
whole life has been shattered due to this.
How old is she?
Age 30 years, two daughters, 9 years and 14 years. Girl is there, one, attaining to be puberty. Whatever the punishment has got it. And whole now keeping in consideration of the children, your lordship.
Take a seat.
Lordship, if lordship permit me, there's a judgment by the Justice Rishikesh Roy, sir. Article 21 and overcrowd in the jail. That is our justice. Last breaker.
Yes, Mr. Sharma, what do you have to?
Lordship, the health status report is already in the file, Lordship. It states, Lordship, regarding the irregular menstruation, Lordship, and nothing else, Lordship. No serious ailment is there, and she is found to be medically stable now, Lordship. That apart, Lordship, one of the PWs has already been examined, and as per the records, Lordship, the last date was 21/3/25. After that, Lordship, whether any witnesses have been examined or not, Lordship, that is not clear. So Lordship, trial is progressing, and already, Lordship, commercial quantity, he has not submitted on section 37, Lordship, because without deciding section 37, Lordship, the satisfaction that is required, bail cannot be considered, Lordship. That is wonderful. And altogether, there are 10 PWC.
Interestingly, your lordship, that laws, there is no statement of that laws apartment. And all the witnesses are official witnesses. Two witness came, that is no link with this case. So. All are police witness, lordship. Only three witness, there is no any definition and occupation or any link.
For Dr. B.N. Gogoi, Learned Counsel appearing for the petition. And Mr. P. Sharma, additional public prosecutor appearing for the state. On perusal of the records of the case. It is seen in that records of NDPS case 75. Everything else was. Or 20 case 128 of the two. It is seen that the order sheet is available only up to 07032035. Call for the legible scan copy of the orders as well as the evidence of the prosecution as on 2nd of May. Pertaining to NDPS case number 75 of 2024. From the Court of London Special Judge NDPS. Kamrup Amingaon. List on 8th of May. The registry shall communicate this order to the London Special Judge NDPS. Kamrup Amingaon forthwith. This order be brought to the notice of the registrar's official. List accordingly.
Deeply obliged, lordship.
But here I am appealing for the informant matters. Informant brother of the deceased and the victim who was raped and killed. The early we hours of in the absence of her father, we had gone to Masjid Mal for namaz within the time that was happened.
You want to make your submission today?
There's a lot of flags.
Or if you want, today we'll hear you. because-
yes. Yeah, lordship, I am ready in fact. Yes, I can make one. Yeah, two only only now 10 years.
Let us start.
Yes.
Your lordship may just see the original facts of the matter, which is at page 4, paragraph number 4 of our petition. If I may read, your lordship.
Just a minute, just let me go. Charge frame under which section? Charge frame under which section?
On all the sections, 376, 302, and section 4 of the POCSO Act.
Mr. Sharma, have you gone to the record? But you gone to the PM report? Yes. Section 6 will come.
Lordship may not come, Lordship, but regarding 202 and other.
No, those are different.
Yes.
Now, why I'm saying, say, this court is only related to
Bail.
special act.
Yes, yes.
Now, if it is not under the special act, this provision of special act doesn't come.
Yes.
Then this matter will go to the other court. That is one issue. The postmortem report indicates something else.
Yes.
You have gone to the. It doesn't indicate about
Yeah.
accepting the bite marks
Yes, yes,
in the breast of the child,
yes.
in the both the breast. There is nothing else.
Yeah.
Of course, there are
Manual strangulation.
that is the reason you're asking, in fact, the forensic report also could not
Okay.
ascertain
Yes.
those things.
Yes.
If POCSO Act doesn't, it's only P0. It's different. That's what, then it have to go to the different court.
And my respectful submission will be, Lordship, under this jurisdiction, Lordship, it cannot be presumed that 6 will not come, Lordship, because this is only an bail application, Lordship.
No, it is the reason we're asking.
Yes.
Because whatever we have seen from the medical report.
Yes.
Comparing to section 6. Accepting those two things we have seen. in the-
Yes.
Yes, it's the diet of strength.
Yes.
That is it. But whether the POCSO Act will come, offenses in POCSO Act. Good. The Sharma, you also go through the whatever we have seen. The charge has been framed.
Only one 11 witnesses examined,
No, 9.
9.
Almost, it is almost at the end of the trial, Lordship. Almost every.
Okay, we'll come back at 2.
Lordship.
You let us know.
Lordship. Oh,
Ms. Bureau, tell us, what is the stage of the proceeding now?
Almost the PWs are done. And the petitioner has suffered more than 2 years, 5 months and 6 days. Your lordship. The more important part here in this case is, even if we see the medical report, post-mortem report, 376 doesn't even arrive. Because if your lordship may just see page number 64. Page number 64, it is very clear, which is the part and parcel of the post-mortem report. Nothing is there. So far as if if that part is missing, so ultimately section 4 will also not attract. Secondly, we do have sympathy for the victim, but regarding that strangulation, the police in its charge sheet says we have a fingerprint and the fingerprint is identical. But whereas if we go to the FSL report here, FSL report says that we have not yet ascertained the fingerprint. Moreover, if we go through the statement of the cross, the informant itself has said, I don't know what are the contents of the FIR, what is written in the FIR, nothing is there.
That's not necessary.
But even though,
It is only an instrument to.
yes, but even though the long prolonged incarceration which we have suffered and which I had to undergo, that is quite uncertain. Because I will just like to rely on this one judgment. This is the Javed Ghulam judgment.
What is the funding of the apex court?
Yes, paragraph number 18, 19 and paragraph number 20 are much important. I will read 18, 19 and 20, if your lordship allows. It says, criminals are not born out but made. The human potential in everyone in good and so never writes off any criminal as beyond redemption. This humanist fundamental is often missed while dealing with delinquent juvenile and adult. Indeed, every saint has a past and every sinner a future. When a crime is committed, a variety of factors is responsible for making the offender commit the crime. Those factors may be social, economic, may be the result of value erosion and parental neglect, and maybe because of the stress and circumstances or the manifestation of temptation in a milieu of affluence contrasted with indigence or other privations. If the state or any other prosecuting agency, including the court concerned, has no withdrawal to provide or protect the fundamental rights of an accused to have a speedy trial as enshrined under Article 21 of the Constitution, then the state or the any other prosecuting agencies should not oppose the plea for the bail on the ground that the crime committed is very serious. Article 21 of the Constitution applies irrespective of the nature of the crime. We may hasten to add that the petitioner is still an accused, not a convict. The overarching postulate of criminal jurisprudence that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly, howsoever stringent the panel law may be. So this was one of the observation of the division bench of the Supreme Court. And moreover, even in the Manish Sisodia's case, which is a very recent case, there also the Supreme Court has classically and categorically specified the right of Article 21 of the Constitution. That even a day before a judgment also, the accused also has got each and every right to get a bail. And there is no any hard and fast rule for that. This is only my humble submission. Otherwise, if your lordship may just see the informants, the father of the informant, the uncle, the sniffer dog report, each and everything which we have annexed with the petition goes in my favor. Because there is nothing which can prove that I am a guilty of an offense. This is only my respectful and humble submission before your lordship. And your lordship, only just my two more points I would like to add to my submission. That one is that just because this the prolonged incarceration has been taken place, so there is a heavy doubt whether I will be given a free and fair trial to justify myself before the court of law. The second is section 172 of the CRPC. 172 subsection 2, which says any criminal court may send for police diaries or a case under inquiry or trial in such court and may use such diaries, but not as an evidence, but to aid it in such inquiry or trial. So these two humble submissions I would like to add, your lordship.
Mr. Sharma, this will dictate the order.
My lord, already witness have almost prosecution is already complete. Only my lord, or if there is any DW, there is otherwise pronouncement judgment.
Mr. Sharma, I think
Yes, Lordship, Lordship is already aware of that judgment, Lordship, expresses state of
that is,
heinous offences, Lordship, it also contains murder. And Lordship, there is no law impaired relation, Lordship, because already the trial is at the fag end of completion, Lordship, almost. And Lordship, regarding just one point, Lordship, Lordship has seen the statement of the dog handler, Lordship, court witness number 2 and 3. They categorically stated how the dog sniffed the, that's Lordship is aware.
can we go through that part, evidence?
Yes.
Because already
No, no,
20 witnesses have been, and 3 court
Yes,
witnesses.
yes.
And 20 prosecution witnesses, evidence has been
Yes.
recorded.
I'm simply stating, Lordship, because there has to be a link, Lordship, because Lordship will be looking at the link. That is the link, one of the link, Lordship, which points to the guilt of the accused person. Because even if we, just for argument's sake, even if we.
You have gone through this report, right? You have gone through this report.
Yes,
Have you find that exhibit 17? Because that is the report where the forensic report regarding fingerprints.
yes, Lordship.
Have you gone through that?
I will mark-
I didn't go to the in that details.
I will mark it, Lordship.
There are, your lordship, in fact, many catches. Because the sniffer dog report says that while the dog inquiry was done, the dog came out with a chain. But someone says that dog sniffers team which came, they were in the civil dress and dog came out with nothing in the mouth. And the informant here itself says, which is at more interestingly, which is at page 26. If your lordship may just have a look for a once. Page 26.
Kindly read.
Your lordship?
Kindly read.
Yes, page 26 says, today I could not remember if in my FIR it is written that the accused at first raped my deceased victim's sister and then he killed my deceased victim's sister by strangulating her. Since I could not read and write, so I do not know what is written in the Azahar. My FIR was written as narrated to me by my uncle Hanif Ali. And after that, the writer of the FIR has written my FIR. I could not give only my signature both in English and Assamese, but I could read and write English and Assamese. The accused has had bad relation with the other co-villagers as because he is a quarrelsome person of our village. When my father had left for morning namaz, then he just closed the door by pulling. Then further he goes into says the third para. It is not a fact that seeing my deceased victim's sister lying there dead, then the accused ran away from our house by breaking the boundary fencing of our house to his house. Now there is again the second question comes, your lordship. Generally, if out of love and affection, if we take any child from anyone, so we see the normal behavior of the child, that the child either shouts or cry louder. So even when this victim was strangulating by her neck, no one has shouted and no one has listened to the voice. Huh? So there are certain lacunas in this. More importantly, this says that what has been stated by my uncle Hanif Ali has been written in the FIR. Now, even if your lordship may see the
informant was not at a place of occurrence.
Yes.
He was.
yes,
was
that is also one another aspect.
That is why but thing is this, the very first thing, there was a GD entry in the early morning at 7:10 PM, 7:10 AM on the date of the occurrence.
Yes, GD entry, other things may be there. But
Right.
in the cross, the other materials which was placed and which are presently a record of this petition clearly states that nothing is there in against
Be
me.
a good ground for an appeal or whatever at the time of arguments, right?
But even though,
Before the trial court.
yes,
For the purpose of failure to tailor,
but that is only our main question, your
only
lordship.
having a good point of argument during the
Yes.
trial.
Appeal may be there, quashing or other remedies may be there. But even if I don't get a bail, then how will I justify myself to be a part of a free and fair trial? Because they may have the PWs. I may also have DWs in my support, who knows? So even if I don't get a chance, then how will I be able to justify myself before the trial? Even the framing also that under the aforesaid sections, that are also something which is not acceptable based on the evidence placed on the record. So there are many facts, many facets, lacunas in this entire procedure. And therefore, just only I will pray, Your Honor, may just grant us a pay. If required, necessary condition may be imposed, we will be abiding by the same.
Lordship, one last submission, Lordship. In this bail application, Lordship is not required to wait the evidence and come to a finding whether it is for acquittal or conviction, Lordship. That is not the case. Lordship will only go through the records if there is a prima facie case for grant of bail. In that regard, Lordship is well aware, Lordship, regarding the judgment also, Lordship, heinous offences. And just to point out just one point, Lordship, if Lordship will kindly take up the application, bail application, and come to page 42, I'm just pointing out, Lordship, one thing, Lordship, regarding his conduct, Lordship. At page 42, Lordship will kindly see deposition of PW10. There are other witnesses also, Lordship. This happens to be an independent witness. Page 42, Lordship. Yes, Lordship will kindly come to the first paragraph. Down below, Lordship will find accused Hazrat Ali, who followed us in line number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yes, 42. 10th
Yes,
line.
I've seen that.
Yes.
It starts, the line starts with and,
No, Lordship.
A and D on the left side.
No, Lordship. Response to our call. It starts with response to our call.
Yes.
Yes. Accused Hazrat Ali, who followed us, he tried to pull down the body of the deceased victim from her bed and asked us to bury her immediately as she had already died. In the meantime, other co-villagers also arrived at the place of offense, and then the accused was resisted from burying the deceased victim as because it is a police case. His conduct, Lordship. And again, Lordship will come to page 45. One more witness is there. PW11. First paragraph, Lordship. Second last line, Lordship. In the meantime. In the meantime, accused Hazrat Ali also arrived there and told that since the deceased victim daughter has died, so it is necessary to bury her as soon as possible. but my poor villagers did not agree to his proposal as because it is a police case and then someone had informed the police and so on. So Lordship, I am not relying on all this, but there are materials, Lordship. So at this stage, a finding as regards whether it will be a conviction or acquittal, that cannot be done. That is my humble submission. There is a prima facie case. Heinous offense, Lordship, the judgment rendered in X versus State of Rajasthan is very much clear, Lordship, division bench. So that is my submission.
Even though there are materials, your lordship, but even though that cannot suffice my prolonged incarceration. Because if I succeed, suppose in my quashing or in my appeal or other remedies, then the long incarceration for which I had to undergo, will the state will be able to give me that compensation or not? Because so far as the submission, the last very submission which was made by the other side, it is of page 45, and who is the father of the deceased. And he himself admits that earlier I, along with my family, resided at village Palash Pathar, and I have started living with my family in the plot of land, and that I have purchased from accused Hazrat Ali since last 5 years. So the entire anguish and the fight was for a land dispute. Later on, who killed, who didn't kill, for that, the petitioner was made an scapegoat. Whereas just for the sake of humanity, I was working as a labor under the contractor in Guwahati. When I heard the news, just for the sake of humanity, I ran to that spot, to the family. But immediately I was being taken into custody by the police. So this is what everything is before your lordship.
Pardon me. Applicable and it's also a heading for the petition. And it's a feature. And what's very- Also heard Mr. R.P. Sharma, let's hear also. Assisted by
MK Sharma.
M.K. Sharma. Assisted. Heard also. Referring for the information. That is application under section 483. File on 24/02/25. The petition amendment is sitting date in special POCSO case number 45 of 2023. Arriving after the Calgary Police Station case number 337/2023. Corresponding year number 2120. Public 2022. In which are under section 376 within the 3. Public 202 IPC. Review section 6 of the period of the person framed against the petition on 07/06/2023. The metric 20 for the court of running special test box which connects to Facebook. Right. It is submitted by the petition that he was arrested in connection with the on 16/11/2022 and since then in custody. For more than 2 years. Five months. It is also some that recording of everything. A prosecution witnesses. It's almost complete. Considering his detention in custody since 1911 and the stage of the trial, if the petitioner is not released on bail in say special custody, there is all possibility that he will not able to defend his case properly. If not repeated. Thereby, he shall not have any fair trade in the state special box. Placing the evidences of some of the prosecution witnesses, including the informant. A plural and a counsel appearing for the petition. Submitted. For the petitioner submitted that. There are discrepancies. And as such, discrepancy material evidence. It is by the prosecutor. And as such is entitled for it. Both Mr. Sharma and Mr. Peacher, the state president, Mr. R. Peter Miller, chair of preparing for the home. That prima facie, there are sufficient materials against the petition with regard to his involvement with against crime. And at this stage of the trial, petitioners' bail should not be considered. By order it is 03032025. The court called for the records of scanned copy of the records of special box of case number 30, along with the records of the from the records of the case, it is seen that the learned trial court, ID Court of Learned Special Judge Foxco, Sonitpur, have already recorded the evidence of 20 numbers of prosecution witnesses adduced by the prosecutor, as well as 3 numbers of court witnesses. Peruse the post-mortem report of the deceased. As well as the forensic post-mortem report of the deceased. Fifteen 11/2023. And the forensic report including the fingerprint report submitted by the Directorate of Forensic Science. From the record, it is also seen that on 15/11/2022. The morning around 7:10 AM. Police in the Dhekazali police station received a telephone call that a girl was found dead inside her house. The said information was accordingly registered as Dhekazali police station. DD entry number 387 dated 15/11/20. On receipt of, on recording of such DD entry, police personnel from Dhekazali police station visited the place of occurrence. As per the FIR, written FIR, it is 16/11/2022. Lodged by the informant respondent number 2, elder brother of the deceased, minor victim girl. The case is that on 15/11/2022, in the morning around 5, while the father of the informant proceeded to the mosque for Jummah prayer, he called upon his daughter, the victim, the deceased, and wake her up. After about 45 minutes, when he returned home, when the father of the returned home, he found the sister of the informant, minor sister, dead inside his house. Police were accordingly informed by the neighbors. And they arrived at the place of occurrence. Initially on suspicion, police apprehended the petitioner. And during inquiry, the petitioner admitted that in the absence of any person in the house, he committed rape. The minor sister of the informant, and thereafter killed her. Speculation. The said affair of the informant respondent number 2, dated 16/11/2024, was according registered as Jackagon Police Station case number 337 of under section 376 of the 302 Act of 396, 4 of the case. The postmortem report of the deceased indicated injuries within bracket bite mark on both the breast of the deceased. Finger tip aberrations, including fingernail aberration. On the both side of the neck of the deceased. And contingent over lateral aspect of the right side of neck. Of the medial to right acromion process. Below and posterior to right ear fallopian tube. Which are anti-mortem manual strangulation by hand within the throttle. Court witnesses. The personnel of dog squad also indicate as to how the concerned dog of the dog was behaved. Indicating about the involvement of the accused petitioner in the alleged crime. Fingerprint experts as prosecution witnesses in their evidence indicated that fingerprints of the accused petitioner match with the fingerprints found inside the house of the informant where the deceased was found dead. It is already noted above that the prosecution has adduced evidence of 20 numbers of its witnesses. And the trial could have also recorded the evidence of 3 court witnesses. Evidence of 3 court witnesses. Ms. Burua, learned counsel appearing for the petitioner. Relied on the judgment of the Honorable Supreme Court in the case of Javed Devidi Ghulam Nabi Sheikh versus State of Maharashtra and another. Reported in 2024 7 SCR 992 equivalent to 2024 INSC 645. Paragraph 1892. On perusal of the safe judgment of the Honorable Apex Court, the case of David Ghulam Nabi Sheikh, it is seen that the concerned accused was taken into custody as 1193 numbers of counterfeit Indian currency notes of denomination of rupees 2000 were recovered from his bag, and he remained as an under trial prisoner for a period of 4 years, where the trial court did not even proceed to frame charge. And the concerned prosecution intended to examine not less than 80 witnesses. Considering such material, the Honorable Supreme Court, the said case of David Ghulam Nabi Sheikh, granted him bail. However, in the present case, the petitioner was arrested in the evening on 16/11/2022. Charge sheet was filed immediately on 07/06/2023, I think. Yes.
23, my lord.
And the concerned trial court as on August 2024 have recorded evidence of 20 numbers of prosecution witnesses and 3 court witnesses. In last 01/04/2025 was the date fixed for recording the evidence of the investigating officer of the case.
No, I think on 20th of May, there is a, I'm just told, I'm not confirmed. 20th of May, next date is for, I think, delivery of judgment. Yes, what do you, but the person is not with literal manner to me.
No, and so far as the information we received is that now once the PWs are complete, so the VW will be started. And moreover, the petitioner, your lordship, he doesn't even have any father, mother, no one, only the sister. And the sister has filed this petition on behalf of the brother.
That we have seen.
Otherwise, what will happen is, your lordship, this petitioner has 3 or 2 bighas of plot, which is now under possession of the villagers and as well as the father of the deceased. This is what it has been brought to our notice.
That you can always place it during the trial, right?
Yes, yes, but for that and proper and adequate opportunity is our right.
But what we have seen that legally the defense counsel is doing his duty,
Yes,
he is there all along. We have noticed to the records of the. The Honorable Apex Court. In the case of X versus Rajasthan. Reported in 2024. NFC 909, equivalent is 2024 STPL. 124 in 98 SC. And tell that's for.
yeah.
From the above. We have, it is seen. That. The right of the accused. To have. A speedy trial. The accused petitioner. Outside. Special POCSO case number such and such. Has not been infringed. Considering. Such materials. In the case report. And. For the reasons above. This court. Will not be opinion. On that. It is not a quick case to file petition. Okay. Considering it. 1611. Stands. Protected. Escape.
Obliged, my lord.
Deeply obliged. However, to your lordship, just one further prayer. That because the 19 is the last date of the Supreme Court. So we actually wanted to try once more. So with the liberty to approach the Supreme Court.
Why not? There is no liberty is required. No liberty is required.
Deeply obliged. May I please your lordship? Lordship, this is 483 of the BNSS petition, my lord. Petition is 209 days behind the bar. The informant has appeared, my lord.
counsel appearing petitioner.
My lord, mhm.
Just. Mr.
M. Rahman.
Peter Mark. Alright. Also heard Mr.
M. Rahman.
M. Rahman, direct counsel appearing for the comment. That's all. By this application, I'm also. Afraid or fail. Special. Put in bracket Foxco case number 109. Driving out of the Korea station. Case number 165. Corresponding to the number 766. Which. Are number sections. Six or six, six. Was free. Against the motion on 1811. Pending. Looking for. Yes, Ms. Burrow.
My lord, initially the FIR, my lord, with regard here and on the length of detention, my lord, 209 days as on today, my lord. And my lord, out of my lord, 9 witnesses, my lord. Till the filing of this petition, 4 witnesses, and as per my knowledge, my lord, 1 more witnesses has been examined, my lord.
So the 5
5 witnesses, 4 witnesses, I'm signed by 1 I have paid for e-court services, so I'm not signed, but I love 5 witnesses I examined as on today. And my lord, the victim and the informant, my lord, they are examined, my lord. And the other witnesses that are left behind are the, my lord, 1 is an independent witness, no doubt, and other 3 are the, my lord, court witnesses, and my lord, the IO and the medical witness, my lord. And my lord, here my submission is the petitioner has no such past antecedent. He is the permanent resident of the locality, another aspect. And my lord, here, my lord, the petitioner, my lord, the my lord, I know it's a certificate matter, the factual will not work out, but my lord, my submission is that they have in the 164 statements, they have stated, my lord, there was no doubt a love relationship for 1.5 years, my lord. And the instant FI was lost after, my lord, more than 5.5 months delay, my lord. And thirdly, my lord, the informant, who, the victim, my lord, the victim has stated that, my lord, that my lord, the victim has stated that this FI has been lost by the father after her sister has been drove out, and which has also been admitted by the sister, my lord, who has stated that after the person came to my house, it was lost, my lord. The fact stated by the in the deposition by the father is that her daughter was not present, went on this space, and after that, after coming to later on, when the sister was over, he has lost this FIR. According to the victim, she was there. Thereafter, on the month of September, again, as the accused person has tried to molest her again, thereafter, informing the father, the FIR has been lost. According to the version of the PW3, my lord, who is the sister, she has stated that after she was dropped out from the house because of this matter by her in-laws, thereafter the father has lost this FIR, my lord. And my lord, here, so my lord, I submit that in the long run, my lord, no doubt it's a case of sex or POCSO, my lord, I'm aware of that. But my lord, in the long, this petitioner has no such past antecedents. The main witnesses are examined. There are no chances of tampering the evidence. And the crux of the main issue in which we are going to give the DW is that in Mauritius, they went on a bike wearing traditional attire. Photos were there. I have annexed that also. On that day, there was a marriage ceremony. I have stated clearly, there was a marriage ceremony in Morisapatra, for which they went to attend. And the whole village was more or less present. There are photographs and which we are going to submit in DWs. I cannot submit it now because it will weaken the case of the defense at this stage, but I categorically stated the fact. And as the sister was dropped out because the in-laws had a knowledge that she used to have a love affair with the petitioner, the own sister. And for that reason, because of this reason, they wanted her to be married, the victim. But at that time, my lord, the child marriage situation was going on everywhere. So 1 year, since he was 17, they told for 1 year, and then this FIR has been lodged, my lord. This person has no past antecedents. They have a love affair, my lord. Moreover, permanent resident, every witness has been examined, there are probable signs of tampering. There is no such incident. So he may be granted an opportunity to face the remaining trial with any stringent conditions from outside, my lord.
I have objection, my lord, because if he was granted bail, my lord, then he again come to my house, my lord, and molest my daughter, my lord. There is this chance, my lord. And moreover, my lord, out of 5 witnesses already been examined, my lord. It is speedy trial, my lord. Very fast trial is going on. So let it finish, my lord.
Yes, Mr. Sharma.
Your lordship, the date of birth lordship is in 27/11/2006. Of the victim girl, she is apparently a minor. And lordship, from the records, only 3 witnesses are there. Other 2 witnesses, the records are not updated, lordship.
So there is a report has come. PW for the doctor concerned.
Oh.
But also.
Oh.
My lord, that I am not so certain.
Out of 9, 5 witness, 5th witness is not, the position of the 5th witness
Not in the record.
For revealed that the court, the
Yes.
doctor was outside.
My lord.
The case lordship, otherwise the lordship is done to the evidence also, lordship. There are some discrepancies, no doubt, but
It's contended by the petition that the victim who is of more than 17 years of age was having love affair with him. And on the date of the incident, there was a marriage of their relative at Moricha Hotel, to which he took the victim and did not commit any such act as alleged in the FIR. It is also stated that as the victim was less than 18 years of age, he did not marry her at that stage. And the informant, after more than 5 months of the alleged incident, lost the affair of the case. More so. And the eldest daughter of the informant had left the house of her housemate, left the matrimonial home, her matrimonial. It is also submitted by Ms. Purva that in the meanwhile, the 5th evidence of the 5th prosecution was recorded by the trial court. Including the informant and the victim direct. From the evidence of the prosecution witnesses so far reported. Ms. Burwa also pointed out certain discrepancies. For such reasons, Burwa has prayed for bail of the petition on any stringent ground that can be imposed by the court. All kinds of things. Thank you. Do you have the forwarding report with you?
My lord, page 17. Annex 2, page 17, my lord. My lord, the ground number 4 is also there. The ground number 4 at page 17 may kindly see. They post it from all sides.
No, it is in that, it is in the record.
My lord,
The petitioner of that. He has already agreed to marry the victim that. And that extent. An agreement was also entered. The court by order dated 03/03/2025. Call for the records of state space record. Scan copy of the records of state special court case number 109. The court recorded fits of best court. Along with the records of the free appears 165. It is seen that FIR of the case was lost by the informant on 24/09/2024. Alleging that on 05/04/2024 morning around 6:30 AM. The accused petitioner took away his minor daughter aged about 17 years to Moricha to the house of his maternal uncle at Moricha Pattar and forcefully raped her. And also threatened her that if she reveals same to others, she shall be killed by him. The said affair is the 24/09. is also alleged by the informant that in his absence, the accused petitioner came to his house and on 2 occasions he had committed rape on her. Further, the accused petitioner called upon grandfather of the victim girl on phone and handed over her to him and thereby sent her to her ex. Said affair was accordingly registered at the Korea Police Station case number 165 of the It is seen that the petitioner was arrested on 25/09/2024 and in custody in Czech Republic and in custody. From the records of the case, it is seen that during investigation of the case, statement of the victim, girl under section 183 PNL recorded. (25/09/2024) by the Court of Learned Judicial Method first class. Not copy. And was also medically examined. Dr. for medical college. Further, during the investigation of the case, police seized the original birth certificate of the victim girl. Issued on registered on 08/12/2006 and issued on 10/02/2007 by the senior medical and health officer. Register of Botany. Indicating date of birth of the victim, 27/11. As such, on the date of the incident, on April 05/04/2005, the victim was about 17 years. He was medically 55. In a statement before the statement in the section 180, we are assessed. The victim implicated the petitioner that he forcefully took away her though stated that he will take her for a ride, but he took her to Moricha Potter, the house of his maternal uncle. Wherein he was confined in a room. And had forceful sexual intercourse with her. The victims were also stated before the Lanark magistrate that the accused petitioner threatened her that the reveals the incident of committing rape on her. She shall be killed by him. As her father lived outside their house, away from the accused petition subsequently committed also subsequent to the death of her two officers. They were part of but they out of fear could not do anything. But on the 3rd of April, when he again tried to do such illegal act, her mother and children resisted. Then they threatened her, threatened them that the marriage of our elder sister shall be interfered as her two as our elder sister, which are buried, she is near the house of the accused. As our elder sister was thrown out of her house as she did not bear any child, leave to her second of three. The father of the victim will close the affair at the market of Britain. They did not close any affair against it. Out of fear, which might cause the disturbance of the family life. It is seen from the records of the case that police, after completion of the investigation, submitted the charge sheet. P092024. Against the petitioner. Under section 366 or 376 PC review section 6 of the PSC itself. Third, under section 366 or 376 PC review section 6 of the PSC framed against the petitioner on 18/11/2024 in said special purpose. It is also seen that as on eighteen zero three 2025. Evidence of 4 prosecution witnesses. I mean, recorded by the London Trial Court, ID Court of London Special Judge Box of Input. At not looking for inside. Special Poco case number 135. Including the informant, the victim girl, her elder sister, as well as the doctor concerned to examine the victim girl. On 25 years time. Very good. Doctor of the Lakhimpur Medical College Hospital. During the deliberation of the matter, but Ms. Borough Council appearing for the petitioner and Rahman Lalit Council for that. In the meanwhile, the trial court has also recorded the evidence of
My lord stands to correction. I have seen the equal service. Summons were issued, call for not received. So resummon were issued. 50 is not examined. 4.
Prosecution out of 9, out of 9 prosecution cases named in charge sheet, including informal. It is seen from the report of the case that the informal, sorry, the accused petitioner was of 24 years at the time of the incident, whereas the victim was 17 years. That's what it said. Considering the older materials in the course of report is of review that the extension of the petition takes place 25 to 9. Yellow. It's special for this process. That's very important. Thanks.
Obliged, my lord.
May I please, your lordship? This petitioner, he was in custody for last 72 days, my lord.
Just
The principal of a school, my lord. The lordship kindly turn to, before going to the FIR, my lord. Lordship kindly turn to my petition, my lord. Paragraph 6, page 5, what has actually happened. The one lady, the girl, my lord, she was caught red-handed in a very compromising position, my lord, with the warden on 1/2/2025, my lord. Then warden been expelled by me, my lord. And later on, I again came to know subsequently that lady again tried to get away from the hostel with that particular warden again. Then the incident happened. Beating part is there, my lord. But it cannot be an abetment to commit suicide. There's no instigation on to commit suicide. She was taken to home. Then again, I visited the house of the informant to inquire about the whole incident, inform the parents. Yeah, after the first incident, my lord, the informant herself, they have requested me to be strict one.
Class 9 year, 9 student, Malak, she's at that time she is 15 years, 2 months. And due to that incident, Malak, she was badly beaten and on 1st of February, she was taken to hospital. And after preliminary treatment, Malak, she was taken back to home. And but as per the statement of the Malak, other family members, Malak, she is not behaving Malak, normally, Malak, pattern and all this Malak there. And principal visited the house on 4th. Seeing the principal Malak, she became furious Malak, at that moment Malak. And subsequently on 5th, she by hanging Malak, Suni Malak, suicide. And as per the postmortem report, Malak, though there are some Malak, injuries Malak, lacerated injuries Malak are there Malak, below the knee and all this. And opinion regarding this opinion regarding the cause of death is pending till the receipt of the chemical analysis test, etc. That is not yes, received.
Date is not disputed here, my lord.
As
Reason
for
is
the family members also commit suicide. But situation for committing this suicide in front of all the students and all these a 15 years old girl, class 9 student, he was beaten by the principal in front of all. And there are photographs, to see. That's true,
but we are, I'm not denying the
principal informed the family members and all these, how she was beaten. And subsequently that untoward incident happened, my lord.
whether it can be instigation, my lord.
Like-
Instigation is something different, my lord. Absolutely different to commit suicide.
Percentage case.
Well, I have relied on full judgment on the similarity.
We have seen it is here.
Yes. And I am relying on the judgment of Geo Varghese 2020-21, my lord. Paragraph 28 of 2021 judgment, my lord. Lordship kindly peruse that paragraph 28 to 31, my lord.
He surrendered on 10th of February.
Yes, I have signed that.
Considering his detention in custody, do you think further, I have not yet seen the case that further custody detention is required?
As well as 72 days. 10th of February.
Yes, 72 days.
72 days. Only on length of detention, otherwise, well, at one royal mallet committed suicide, maybe committed suicide mallet because the situation she faced before all the
Only students. This cannot be an instigation at all, man. Reprimanding a student. It's my moral obligation also, man. Maybe I have exceeded, but that does not mean that it is instigation. Instigation is totally different. Parameters are there. There has to be my intention how to commit suicide. That is, there has to be there. Check only that what with them. 4 years from, I mean, mentally, मतलब that is the one incident which
No doubt he's not a fit to be a principal.
yes. But
He's
photographs
not fit to be a principal because
shows
corporal punishments are no longer there.
that's a different, but the instigation has to be there. Instigation,
These things, you see, that is why
because I must have the intention to force us to commit suicide.
This, things are different now.
That's the Geo Varghese says, well, the judge,
You understood?
the Geo Varghese says that what is the purpose of a principle, well, this paragraph is very clear.
That, you see, that is a case where the,
Bunking of schools.
that is a case where the concern physical instructor or physical training instructor
Yes.
have complained for which the principal of the school called upon the parents. So there is an allegation against the physical instructor or the PT teacher that he was harassing the child. Right? That since there was harassment, that was compared with the investigation to the question of there are things are very different. It's a question of thing is this see. The child only will commit such crime. It's not a crime. Child will not commit if he thinks who will commit, not the person who is edited.
Well, that's a
But
different, but
that-
whether I had the intention to commit her to suicide. Just because, yes, I have punished, I have given the punishment, I may exceeded.
That is what. That's
Yes.
what we have been saying. That is the reason we are saying.
Yes,
that
yes.
kind of
Yes,
That is
I'm,
why-
I'm on not on that matter, that the,
person is
whether
not
he
fit
should,
to be a principal.
yes, that's a different issue, my lord, but the criminal intent to her to commit suicide, that is not my intention, my lord. My intention was different. But then again, why I have visited her, my lord? I have visited her to inquire about her health. On that day, she agitated. Then she committed suicide, not on that day itself, my lord. That's very important. On the, what is incident has happened on one. On the first, then I have visited to inquire about her health. On fourth, that is in the admitted fact, in the FIR itself. Being the principal, I went to the house of the informant to inquire about the health. So she got frightened, then she committed suicide. Unfortunate, madam, definitely, madam. But this is not an offense to abatement of commit suicide. That's a different pretext, right? Altogether, both are different. I must create a situation that there is no option for her to commit suicide.
That is, to some extent, Malad, that is, yeah.
Because I just visited her place to inquire about her health. Does it mean that I have compelled her to commit suicide, my lord? I have created a situation, my lord, going to the house of the informant, my lord, to inquire about the health. And this is the second time that incident has happened. Lordship can also see my conduct, I myself surrendered.
Assisted by Mr.
Ace Bull ಆಗಿದೆ.
Lordship, can you excuse me for?
Yes, yes. Petition and relief, that's it. File this application and on 25 days. Praying for it. Opportunity to discuss with the person. And getting to the criminal justice in the care and protection corresponding to the number 155 in which he is in custody since 10/02/2020. As per the affair of the case, clause on 07/02/2025 before the officer in the court of state. Yes, yes, sir. The niece of the informant in the was a student of class 9 studying at Little English School at Jayarampur, Bukamo, and used to stay in the hostel of this age. On 01/02/2025, her niece was assaulted badly by the principal of the same school. I the petition. That's what it was written up. I have approved it. By the principal of the same, by the petition. That given her the error number of by the fixed rate. During such assault, the alleged that the petitioner also pulled her down by grabbing her hair. Informed of everyone. That's good. Informed. Because of such assault, the niece of the informant was injured badly and lost her properties. Developed high fever. Initially, she was given treatment at pharmacy at Jayarampur. And principal of the school informed the husband of the informant. Without disclosing the truth. Regarding the assault. that he made a on reaching Dharampur, our niece was found lying on a bed, taking oxygen. As her condition related, she was shifted to Kogamuk Public Health Center by on the relief for her. On the same day, on 01/02/2025, she was brought back home from the hospital. Brought back home, he come out from. Because of such assault by the petition, her niece was in deep shock. Depressed, and was doctor center. Was not behaving in the on 04/02/2025, the principal of the school, the petition, visited the residence of the informant. To know about the health condition of the victim girl. But seeing the petition, she got the niece of the informant. But if no question. And out of deep fear, not expected communication. She committed suicide by hanging herself at the knee on 05/05. In the said affair, it is 07/02/2025, the informant alleged that it was such act of cruelty by the petitioner, the principal of the school. Her niece, the victim, committed suicide. And it is the petition who is responsible for the outcome. Please. They say that fire. It is 07/02 was accordingly registered as community police. 06 of 2025 and it's 1.7. PM. The petition on 10/02/2025 surrendered before the community police station and was taken into custody. And it- and- Yeah. Mr. Burrell and counsel appearing for the petition. relying on the decision of the Honorable Supreme Court in the case of Geo Bharti, AR, P.H. versus State of Rajasthan, reported in 2021 online. And Patel, Babu Bhai, Manohar Das and Atul versus State of Gujarat, reported in 2005. That's the same one. From it, that the affair of the case did not disclose any such ingredients of instigating the victim to commit suicide. Mr. Gora, however, admitted the fact the petitioner being the principal of the school had to maintain the discipline in his school. And might have overacted. But did not instigate the victim to commit suicide. There was the case that placed before the court by Mr. Gora. From the case that the statements of the witnesses are going to be reported, but it is seen that on 01022025, the petitioner had written the victim and another boy of the school, the Bengal State, in front of the other students of the hostel. On the same day evening, the afternoon, the victim girl had a problem in breathing. And as such, he along with two girl students took the victim to a nearby pharmacy. In which she was given oxygen to breathe. The petitioner also informed the guardian of the victim girl who came to the pharmacy and took her to the Gomus public. On 04022025, the petitioner went to the house of the informant with whom the victim girl, being the who was the local guardian, with whom the victim girl stayed since 01022025. And the next day, I am 05 15 to 20. The informant in a statement before the IO as seen from the category. Stated that the petition came to their residence on 04/02/2025 and inquired about the health of the victim girl and said sorry for the said incident. And the pen cap. Or on 05/02/2025. In absence of any person in the house. Or the victim girl committed suicide. So she was alive when she was taken to a medical college hospital. But she expired in the hospital. Considering such materials in the picture. There was the PM that posting from the photo of the victim because they requested. Mr. Parasar.
Well,
My lord, item
deeply applied.
item 26, my lord. Already on today, my lord, 81 days, my lord. So let the matter come out late day after tomorrow, my lord.
Good talking. We'll take up your matter and please. Yes.
Let me. FIR at page number 13, Judge. One of them. May I?
Mr. Parasar. This is from Karupati.
Madam.
You have the case with you?
No, my lord.
Just see today what happens.
Well, I have seen
The informant is earlier also lodged an FIR. Of course, the number has been given here. This is from Kariputia, not far. By Friday, you get,
Madam.
right?
Harupati 14 of 25.
This is Kariputia, case number
14 of 20.
14 of 25.
Madam.
The FIR was, what was,
Lost on
right?
just lost.
And then,
Incident was occurred to 25/11/2024. Long back lordship, there is civil.
and then, the FIR, the informant earlier also lost them. Correct. Find out. And tell us. The appears to be a civil, civil dispute.
There's pending lawsuit.
Find out and let us know by Friday.
Till then, I may be protected.
Wait till Friday. Today, to what to do. Consider.
Definitely.
It is customer.
Well, FIR page 11, my lord. The case was called for along with the DNA report, my lord. Today, 81 days, my lord. FIR page 11 document.
Regarding statement of the victim, that is available, her husband statement of the house owner, the incident occurred by the rape by the two other rented person. All are available, but regarding that undergarments were sent for
forensic, my lord. That report is not available with me. Otherwise, statement of the victim, and not on that day. Prior to that, my lord, there are some instances, my lord, bad instances was there from the end of these two persons, and it was informed to the house owner. As per the house owner statement, that was there, that these persons are not giving some bad intention to the, my lord, victim. And that day at around 1:30 in the midnight. And only
Just pass on the case.
her statement is available, 183, or 180 on both. And
Only
only
medical done.
medical she refused. Medical she refused. That is given, my lord, মই লাজতে medical নকৰিলো. That is.
Well, 2 months back, she filed a false case against two other persons, my lord. I have annexed this copy, my lord.
Production report case number 6.
In custody since when?
31-1, my lord. 81 days to divide.
Will pass the on.
Lordship.